Good evening. Thank you, Mr. Chairman and members of the committee. Sorry, I've got the wrong thing pulled up. My apologies.
Oh, no worries. And by the way, we have you on House Resolution 325.
Thank you. House Resolution 325 comes out of a great deal of work being done that I've had the pleasure of working with some of these advocates and others over the course of the last year. Some of you may recall at the very end of session last year, in the literal wee small hours of the evening or morning. I don't even remember what time it was. I don't think any of us knew what time it was anymore. We created a new crime of organized retail theft. And it was pulled together pretty quickly in response to some pretty intense pressure and concerns out of the retail community, which, you know, fun fact, have turned out to have not been quite accurate. The Walgreens CFO actually was quoted as saying, maybe we cried too much last year in acknowledging that they had overblown their claims of a surge in these crimes. The bill that was presented was put together without seeking the input of the advocates for human crime victims, frankly, and very specifically those advocates for gender-based violence, nor without the input of the state's attorneys who staff those victim witness positions. And it created a whole new class of victim in the state of Illinois, elevating the rights of retailers, of corporate retailers, over human victims of crime. And that, coupled with some changes that I'm sure that our witnesses will share with you, have put a really serious strain and burden on our system while maintaining this imbalance. I don't think that any of us in this room believe that a rape victim should have less rights than Walmart, but that is what our law states. In our efforts to bring the parties together and find a solution, we've not been able to balance the demands by the retailers with the pressures on the system or the needs of human victims. We continue to work, but until then, this resolution is intended to send a very clear message to law enforcement and the judiciary that our desire as a body is for them to prioritize the needs and cases of human crime victims over corporate crime victims. And I am joined by Lisa Kerner from the Cook County State's Attorney's Office and Sarah Burning from the Illinois Coalition Against Sexual Assault.
All right, thank you, Vice Chair Cassidy. Thanks for bringing this forward. You have no opponents, 6 proponents, the Cook County State's Attorney's Office, Illinois Coalition Against Sexual Assault, the Network Advocating Against Domestic Violence, Women's Justice Institute, and the Illinois Coalition Against Domestic Violence. With that said, I see that you do have some individuals here seeking testimony.
Yes.
Please proceed.
Thank you, Chair Slaughter.
1 second. We're going to open the roll. Madam Clerk. Leader Cabello votes.
Oh, somebody's got to make the motion before you open the roll.
Representative Gazzardi moves that House Resolution 325 be adopted with the roll being open. Leader Cabello votes no. Representative Starver Murray votes yes. Anybody else? Okay. Please proceed. I'm so sorry about that.
Thank you, Chair Slaughter, Spokesperson Windhorst, and members of the committee. My name is Sarah Boyning, and I'm the General Counsel for the Illinois Coalition of Sexual Assault, which is the coalition of 31 rape crisis centers supporting survivors of sexual assault and sexual abuse throughout the state of Illinois. I am here to ask you to support House Resolution 325. ICASA advocates for victims' rights because we know how vital it is to empower survivors as they engage in the criminal justice system. One important constitutional and statutory right is the right to notice of court proceedings. Right now, individual human victims seeking justice for violent crimes are promised timely notice by the law. Whereas companies and stores seeking justice for organized retail theft are guaranteed at least 7 days' notice. ICASA legal advocates who work with the victims tell us that victims of sexual abuse and sexual assault routinely get less than 7 days' notice. It is unfair to provide a better, clearer notification requirement for companies than for individual victims. As the law exists now, the state of Illinois prioritizes notice to companies over notice to human victims of crime. Preferential treatment is given to victims who have experienced property loss over those who have lost loved ones. Notice to stores that suffered financial harm are treated as more important than notice to people who have been physically harmed. Victims of violence and family members of murder victims deserve at least the same rights in our criminal justice system as victims of retail theft, not less. Please ensure Illinois law reflects our state's true values by prioritizing human victims and providing them with equal notice rights. Please vote yes on House Resolution 325. Thank you.
Okay, thank you, Ms. Moyne.
Good evening, Chair Slaughter, Minority Spokesperson Cassidy, and Spokesperson Windhurst. Thank you for your time today. My name is Lisa Kerner. I'm here on behalf of the Cook County State's Attorney's Office, and I'm here to support House Resolution 325. I'll talk a little bit today about the job of a victim witness specialist and the extremely large challenge that our office faces. Our office works diligently to notify victims of court proceedings in a timely manner in each and every case. In some of these cases, successful notification to the victim of court proceedings could be the difference of a dangerous person being released or not. That's simply not the case when it comes to retail theft. Our staff typically get about 20 to 50 new cases a month while still being required to notify on ongoing cases. Many issues arise in particular with last-minute notifications. Many times we are not given all the victim's information, or that information may be incorrect or may change. In particular, establishments may not have a point of contact, which creates difficulties in reaching the appropriate party. There are also times we cannot notify victims before an indictment because the clerical process takes time to be updated. One of the challenges victim specialists face is actually successfully reaching the victim. In many of these cases, victims may avoid answering their phone for fear of harassment from the accused or their family pressuring them to drop charges, and in these cases, our victim witness specialists work around the clock to try to notify these victims. They are placed by this law in a position of notifying a victim of a violent crime, of a potentially dangerous situation, and notifying and following statute. And this is not a decision that we feel they should have to be making. I will also speak briefly. As many of you are aware, the Victims of Crime Act recently, starting on July 1st, will cut funding by 50% across the board. 50% of our office's victim witness unit is funded by VOCA. We have 46 victim specialists. We have 4 supervisors. With these cuts and set to lose 25% of our funding on July 1, we expect to lose 11 positions, or 25% of our staff. So this is already a challenge that we are facing. This is a tough job already, and it looks to be even tougher in the year ahead. Thank you very much for your time, and I am happy to take any questions.
Okay, thank you for your testimony. The roll is open. However, members, any questions, comments? Spokesperson Windhurst.
Thank you, Mr. Chairman. I guess the question after hearing the presentation is, what do we view the solution is? Is the solution bringing the human victims up to the 7-day notice, or because that's what I would expect to hear from Representative Cassidy, but it appeared from the state's attorney's perspective that we want to lessen the notice provided.
It would be impossible to meet a 7-day notice for every crime victim, even under the current funding levels. And many of you know this used to be my job. I used to be the person who wrote the grants to get these positions funded. even at the current levels of funding, 7-day notice to everyone is not feasible. It's just simply not. And so state's attorneys generally can't find a number that they could guarantee for every. What we attempted to do was offer the same kind of recourse to retailers that human victims have under the Victims of Crime Act. So they would be able to, if notice wasn't granted, they'd be able to petition for a do-over. That wasn't sufficient to the retailers.
The reason, my understanding, the reason that 7-day provision was put into the law is because many cases, particularly in Cook County, were being dismissed. Retail theft cases were being dismissed because the retailer was not being provided notice of the hearing, was not appearing in court, and then the case was being dismissed. What is, I guess the question is, what is, prior to this becoming law, what is the state's attorney's practice for notifying retailers? And then what is the policy on dismissal of cases when a victim does not appear in court?
I'll do my best to answer your question. The procedure has always been, and our office is always attempting to contact every victim, and we fully appreciate your efforts to ensure that retail merchants are considered and given that same recourse. Retail merchants are victims as well, and they should be given notice. I'm not aware of any cases in particular that have been dropped due to a lack of victim notification. I do know that that was a story that was out there. However, it's not been our experience that that is why cases are dropped. I think in most cases, the choice is not to proceed.
And who's making that choice, the retailer or the state's attorney's office?
In many cases, it would be the retailer. And, you know, I just don't know of any cases where it's because of the notice. But as to Representative Cassidy's point, if they would want to look at something like having that same recourse where a case was dismissed and it was because of a lack of victim notification. And like I was speaking about in my testimony, I do think that having sort of a better mechanism for contacting retailers so that it's not like the 1-800 number to Walgreens, you know, to maybe have it be the person who was on site at the time or, you know, whoever their specialist in that area is. I think that's good, right? To have that point of contact so that you know you're at least trying to reach the right person. But I definitely would be interested to see more and have that conversation further about recourse so that if that is really why they're not proceeding, which I don't believe it is, that there's a fix to that.
Well, it would be good to get that information. You know, just trying to think of circumstances where a victim's failure to appear in court would result in a dismissal, obviously set for trial, bench trial or jury trial, and a victim's not present, that would result in a dismissal, or an evidentiary hearing, motion to suppress, potentially could result in a dismissal. So it seems like in those situations, it would be easy to give a victim, even a non-human victim, sufficient notice to be in court to appear. Now, often I'm sure the retailers, being larger companies, may be more difficult for that notice to pass along the chain to get the witness into court. But it seems like there is a way this could work, so that way cases that are legitimate and evidence-based cases could be prosecuted. I mean, I don't have no reason to doubt what I'm hearing from the retailers when they say their cases are being dismissed for failure to appear because they're not getting notice. So it would be good to have that looked into.
I can definitely try to provide that with you. And I will say, in terms of the extension to, you know, all victims of 7 days, I think anytime there's a day, you know, a particular time frame that's that strict, it just really ties our hands in a lot of ways. And, you know, in some cases, statutorily, that's not even possible because, you know, we have to have some of these hearings before the 7 days, right? So if we're talking about, let's say, a pretrial release hearing, so statutorily, that wouldn't be available. So there would have to be a lot more work done to get into the details about, you know, which cases it would be appropriate for and, you know, what the proper remedy is for a lack of notice.
Thank you.
And Leader Windhorst, I would love to dive into this with you deeper and try to find a solution. I think that we've been as creative as we can be, and we hit a wall, and that's why we're here with this resolution.
Thank you. Any other members seeking questions, comments? Okay, Representative Gunn-Gershowitz.
Yeah, thank you, Representative, for bringing this forward. And, I think all of us, want to ensure that the message here isn't that we are elevating or prioritizing one victim right here over another. And so, we're hearing loud and clear that, by putting in specific notice requirements for one category of crime, that the impact of that was felt as though victims of sexual assault were, then, felt unheard, unseen, and less important. That's certainly not the intent. And I appreciate that Representative Cassidy has worked very hard to ensure that we rectify that issue. So, I just want to offer that I'm happy to help be involved in that effort, and to the extent that there was that unintended message sent by inconsistent notice requirements, or notice requirements that were differing for one type of victim over another, that I don't think it was the intent of this body to say to a victim of sexual assault that they mattered less. I mean, that certainly would not have been our intent. And I think I can speak for everybody that we want to make sure that, to the extent that we can, that we work towards a solution.
Thank you.
Thank you. Seeing no further discussion or questions or comments, Representative Gonzalez moves that House Resolution 325.
It's already open.
Oh, the roll's already open. Please continue with the voting, Madam Clerk.
Slaughter,
Thanks for bringing this forward, Vice Chair Cassidy. Yes.
Cassidy,
Yes.
Windhurst,
Thank you. I believe that we should be treating victims the same and not prioritizing non-human victims over human victims. I also believe we should not be dismissing cases for failure to give notice to a victim, whether it is a human or non-human victim. With that, all that being said, I'm a yes.
Thank you.
Freese, Gunn-Gershowitz, Gonzalez, Grant, Guzzardi, Olacall, Tipsword, Vella, Hernandez, Avalar,
Thank you, Madam Clerk. There being 14 votes in favor, 1 vote opposed. I thought Leader Cabela was a no. He wasn't a no? Okay. Sorry about that. There being 14 votes in favor, 1 vote opposed, and 0 voting present. House Resolution 325 will be declared pass. Thank you, everyone. There being no further
Thank you.
business before the House